Welcome to Nyay Patsala. Today, we'll try to understand what is life imprisonment in the context of Indian law. So, the question that crops up is that whether life imprisonment means the entire natural life or undergoing 20 years in prison. We must remember that life imprisonment is one of the most severe punishment under Indian law. So, it is essential to grasp the legal nuances and implications associated with this form of sentencing. So, let us look into the relevant provisions in the Indian Penal Code, the Code of Criminal Procedure, the Constitution of India, and other legal documents that shed light on the meaning and duration of life imprisonment. We'll discuss in detail for the benefits of the young lawyers and anyone interested to know about it, the true import and purport of the meaning of life imprisonment. So first, let us look into Section 45 of the Indian Penal Code. Section 45 of the Indian Penal Code defines life. In the context of this section, life means the life of a human being unless the context suggests otherwise. So, in essence, life imprisonment means the entire natural life of a person. So, remember, in the context of the Section 45 of the Indian Penal Code, life imprisonment means the entire natural life of a person. Then next, let us look into Section 53 of IPC. Under Section 53 of the IPC, it talks about different types of punishment. Section 53 outlines 5 types of punishments, including imprisonment for life. It serves as a framework for sentencing in criminal cases. The next section under Indian Penal Code which we should look into is Section 55. Section 55 of IPC states about commutation of sentence. Under this section, it allows the appropriate government to commute the punishment of imprisonment for life to a term not exceeding 14 years. So, Section 55 empowers the government to commute life imprisonment to a imprisonment for 14 years. However, it requires the government approval and it does not automatically reduce life imprisonment to 14 years. The next section of IPC which we should look into is Section 57 of the IPC. Section 57 of the IPC provides the procedure for calculation of the term of imprisonment. Section 57 clarifies that when no specific period of imprisonment is prescribed for an offence, life imprisonment is considered equivalent to imprisonment for the remainder of the convict's natural life with no fixed term. However, for the sake of calculation, it is considered equivalent to imprisonment for 20 years. So, under Section 57 of the IPC, the imprisonment is considered to be up to 20 years. So, now let us look what the Code of Criminal Procedure speaks about. Under Section 28 of the Code of Criminal Procedure or CrPC, sentences by high courts and session judges. Under this section, it authorized the session judge to pass sentences of imprisonment for life, thereby meaning that the convicted person may spend the remainder of their natural life in prison. The next section under CrPC which you should look into is Section 432. Because under Section 432 of the CrPC, it provides the power to suspend or remit sentences. Section 432 grants the state government the authority to suspend or remit sentences, including life imprisonment. But the Section 433 capital A of the CrPC imposes restriction on this power. So, if you look at Section 433 of the CrPC, it it allows the appropriate government to commute life imprisonment to a term of imprisonment not exceeding 14 years. So if you look at section 433A of the CrPC, which imposes the restriction or remissions on life imprisonment, section 433A mandates that a person sentenced to life imprisonment cannot be released until they have served at least 14 years of actual imprisonment. So 433A CrPC says that a person cannot be released who is undergoing life imprisonment until they have served at least 14 years of actual imprisonment. Now let us look into the relevant provisions of the Constitution of India. Under Article 72, it speaks about the President's pardon power. Article 72 of the Constitution of India empowers the President of India to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of a person convicted of any offence, including life imprisonment under Indian law. So, President has the power to pardon any person who is undergoing life imprisonment under Indian law. Likewise, under Article 161 of the Constitution of India, the power is also conferred on the governor of the state, which concerns offences under state law. So let us look into some of the important case laws on this subject. In the case of Bhagirat versus Delhi administration, which was reported in 1985 to SCC 580, kindly take note of this citation, 1985 to SCC 580, Bhagirat versus Delhi administration. In this case, the question that arose before the Supreme Court was that whether individual serving life imprisonment can set off their under trial detention period against their life sentence under section 428 of the Code of Criminal Procedure. In this case, the appellants were serving life sentence and they sought to use section 428 for under trial detention set off. A single judge denied this benefit relying on Kata Singh versus State of Haryana. The petitioners argued that for consideration of convict remissions and the section 432 and 433 of the CrPC plays an important role. Ultimately, the court held that life imprisonment qualifies as imprisonment for a term allowing under trial detention shut off. And it also emphasized equitable consideration in interpreting such provisions in criminal law. Ultimately, the Honorable Supreme Court in this case allowed the appeal and the writ petition permitting under trial detention set off for the accused, but subject to relevant provisions and orders under section 432 or 433 of CrPC. And this decision overturned the earlier Kata Singh judgment and highlighted the importance of equity in legal interpretation. The next important case law on this subject is Ravinder Singh versus State Government and City of Delhi, reported in 2023 SCC Online SC 491. If you look into the background of this case, Ravinder Singh was convicted of raping his 9-year-old daughter, and he received a life sentence under section 376, 377 and 506 of the IPC. The trial judge added a condition that he must serve at least 20 years in jail before any clemency consideration, and the Delhi High Court upheld this sentence. So the issue before the Supreme Court in this case was the Supreme Court has to determine the legality of the 20-year minimum prison term imposed by the trial judge. And the decision of the courts ultimately considered that life imprisonment ordinarily means incarceration until the end of one's natural life. And courts have the authority to impose a modified sentence exceeding 14 years in serious cases, even when the law prescribes only life imprisonment. And it is in this case the Supreme Court held that the appellant's life imprisonment was modified to require a minimum of 20 years of actual incarceration before clemency consideration. And in this case, the fines and imprisonment in default of the payment were also confirmed by the Honorable Supreme Court. The next important judgment of the Supreme Court in this case, in this regard, is 2016 7 SCC page 1, which is Union of India versus Sriharan alias Murugan. In this case, the government of Tamil Nadu intended to commute the sentences of 7 convicts, including V. Sriharan, T. Kunderaja, and A.G. Perivalan. And all these accused were involved in the assassination of Rajiv Gandhi. So the issue before the Supreme Court in this case was that whether the state government had the power to commute these sentences. The union government in this case argued before the Supreme Court that the state government was not the appropriate government in this case. The Union of India claimed that the executive power of the union should take precedence as the Indian Penal Code fell under the concurrent list. And Article 73 of the Constitution, along with Section 432, subsection 7 of the Code of Criminal Procedure, it emphasized the importance of the executive power of the union. In contrast to it, the respondent's argument, especially the state of Tamil Nadu, it argued before the Supreme Court in this case that the appropriate government was the state government. And they contended that the central government power should not be dominant but concurrent. Ultimately, in the judgment of the Supreme Court emphasized the need for clemency procedures to be followed diligently. And it commuted the death sentence of the convicts to life imprisonment with the possibility of remission. And the court recommended that the criteria for considering mercy petition should include the uncertainty caused by delays in the disposal of such petitions also. In the next case, Narendra Singh alias Mukesh alias Bhura versus State of Rajasthan, reported in 2020-21 SCC Online SC 3490. If you look into the facts of this case, you will find that Narendra Singh applied for a transfer to the open air camp under the Rajasthan Open Air Camp Rules 1972. And initially, his application was rejected by the Prisoners Open Air Camp Advisory Committee. And in this regard, a previous writ petition challenging this decision led to a court order instructing the authorities to reconsider his case. But despite the court order, the committee rejected Narendra Singh's application, citing his life sentence and the additional murder conviction as reasons for his ineligibility. So the issue before the Honorable Supreme Court was that whether a petitioner sentenced to life imprisonment could be transferred to an open air camp. In the judgment of the Supreme Court, the court found that the committee's decision was unjustified as the reasons for rejection had already been found unsustainable by a court in a previous case. The Supreme Court noted that the open air camp fell under the definition of a prison, and the rules did not specifically exclude prisoners with life sentences. In this case, the Supreme Court emphasized the purpose of open air camps in promoting good conduct and rehabilitation among the convicts. As a result, the Honorable Supreme Court allowed Narendra Singh's petition, quashed the committee's decision, and directed the authorities to transfer him to the open air camp in accordance with the rules. So to conclude, you must understand what is life imprisonment in the context of Indian law, because it involves navigating a complex landscapes of legal provisions, case laws, and constitutional articles. Although life imprisonment primarily means imprisonment for one's natural life, however, there are provisions for commutation and special circumstances that can alter its duration. The purpose of all these lectures of Nyaya Pathshala is aimed to clarify these intricacies of law so that it offers a comprehensive insight into one of the most severe punishments in the Indian legal system. Because if you look at the provisions of the POCSO Act, POCSO Act, there is a specific provision that in some cases the minimum imprisonment should be 20 years. And if it is life imprisonment, it is till the person's natural death. So, we should understand this concept of life imprisonment. It's a very useful concept from the point of a trial lawyer. I believe that this lecture will be very helpful for the junior lawyers in the bar and anyone interested in this concept of law. With these words, I thank you all for subscribing to Nyaya Pathshala, and those who have not yet subscribed, kindly do subscribe because it's a free. You only have to hit the bell icon and hit the notification button so that we can regularly update you on any topic of law that we upload in the system.